After a week of very public turmoil, convicted felon Donald Trump's Department of Injustice filed a motion last night to formally ask federal judge Dale Ho to drop corruption charges against New York City Mayor Eric Adams. The four-page filing urged dismissal, quote, because of appearances of impropriety and risks of interference with the 2025 elections in New York City. But this move came only after 7 federal prosecutors resigned in protest and in principle after refusing to honor Emil Bovey's demand to drop the charges. Top Manhattan federal prosecutor Danielle Sassoon resigned after alleging that the mayor's lawyers had negotiated for a dismissal in exchange for Adams' assistance with Trump's immigration crackdown. But it was AUSA Hagen Scotton's scorcher of a resignation letter that left many in awe. He wrote in part, quote, any assistant U.S. attorney would know that our laws and traditions do not allow using the prosecutorial power to influence other citizens, much less elected officials, in this way. If no lawyer within earshot of the president is willing to give him that advice, then I expect you will eventually find someone who is enough of a fool or enough of a coward to file your motion. But it was never going to be me. Joining me now is Andrew Weissmann, former FBI general counsel, MSNBC legal analyst, the co-host of the podcast Main Justice, and the co-author of The Trump Indictments, the historic charging documents with commentary. Andrew, it's good to see you. I think you share my kind of disbelief at how things have kind of unraveled this week at SDNY. But I wanted to ask you straight out of the gate. I think Judge Ho orders a hearing in this case. I think he orders a full-blown hearing in this case before it gets dismissed. What would that hearing look like?
So I agree with you. And I think one of the reasons that that's going to happen is because, as you and I know, this does not happen. This is just so unusual to see career people resigning rather than follow an order. And they do that when they believe that the order is illegal and or unethical. In fact, the only other time in recent history I can think of that is in Trump 1.0, when prosecutors resigned in the Roger Stone case rather than carry out instructions that they believed were also improper. So I think that Judge Ho is going to have a hearing, and he has every reason to do it. I can give you 2 reasons I think he will. One is, as you noted, Danielle Sassoon and her colleagues say that there's this improper quid pro quo, and that has been disputed by Eric Adams' counsel. So there is a factual dispute, and that gives every reason for a judge to hold a hearing. That's what judges do when there's a factual dispute. And he can say to Emil Bovey, if you think this is wrong, if you think that that's not what happened, you can come here and take the stand and put your right hand up and swear to tell the truth, and I will make credibility determinations. And oh, by the way, and this, Katie, is something you will appreciate as a trial lawyer, you know those notes that you confiscated and you didn't want anyone to see? Bring those with you. I want to see what the contemporaneous notes are that you didn't want anyone to take out of that room, to see what people were saying about that meeting.
So, Andrew, I want to stay in this because I find the procedure to be just as fascinating as the substance sometimes, right? So you could envision an evidentiary hearing, perhaps in camera, meaning not open to the public, but one within which lawyers, even representing Eric Adams, for example, would have to take the oath to tell the truth, take the stand, and have to attest as to whether or not they were complicit in a quid pro quo agreement with the DOJ?
Yeah, by the way, I think this is an open court. I don't see this as being something that would be sealed. I don't see any reason why, given what has already transpired and has been made public, that this would be something that needs to be sealed. And if there are pieces of it that potentially need to be sealed, fine. But I think this would be in open court. One thing also, Katie, is although I think it's much more likely that there will be a hearing, but if the judge, and that's a big if the judge were to find that someone in front of him was lying, he can refer them for prosecution. He can even appoint a special prosecutor if the Department of Justice refuses to prosecute. His colleague on the bench in the Southern District of New York, Lewis Kaplan, people may recall that name because Judge Kaplan oversaw the E. Jean Carroll cases. He did just that. He appointed a special prosecutor when the Department of Justice refused to go forward. So Judge Ho has a number of options in front of him, but I agree with you. The first one is to hold a hearing about the factual dispute. So, my eyes, what I'm keeping focused on is what I think is going to happen this upcoming week is that factual dispute being resolved by the court.
And so ultimately, we did see that Noel Pross motion, or the motion to dismiss, filed. Emile Bovey having to put his John Hancock on it, despite all of the drama leading up to it. But it was signed off by two other main justice lawyers, because, again, nobody at SDNY was going to sign off on it. One of them was this guy named Ed Sullivan. He's on his way out. He's retiring. But I was really alarmed when I heard that Bovey is having this meeting at Main Justice and public integrity. The irony does not escape any of us, right? He's having this meeting. It's an hour-long meeting, and he's like, somebody better take the fall for this. Somebody better sign this. And in the end, Ed Sullivan steps up. I mean, was this a I love my pension, I want to keep my pension move by Ed Sullivan? Or was this a I am going to come to everybody's kind of rescue, and I'm going to take it for the team?
Well, I think it was the latter. The reports are that a number of people, not just in the Southern District, but also at Main Justice in Washington, refused to go along with the Bovey order, clearly thinking that it was improper to do what he ordered to be done, and that he put all of these people in the public integrity section in a room and said, if one of you does not sign this, I think actually two of you do not sign this, I'm going to fire everyone. I mean, this is like a hostage situation. It's very interesting, as you said, there are two people who signed the actual motion. But if you look at it, Katie, it's really fascinating. While those two career prosecutors have signed it, they actually don't make any factual representations. All of the representations are that Emile Bovey, the acting deputy attorney general, has found X, that Emile Bovey wants me to do this. They actually don't sort of perjure themselves or say anything other than this is what he wants us to do. So that gives one more reason for Judge Ho to ask a lot of questions, because the two of the three people who are signing this submission are really not representing anything other than Emile Bovey is saying this is what he wants. So it was sort of carefully done on their part to not have to own what it is that Emile Bovey is doing here.
Yeah, and it was not only carefully crafted, Andrew, but there was a footnote on page 1 of this filing that made it clear that Main Justice had to enter an appearance on this case because of the Southern District of New York lawyers. Remember, they got suspended. They got suspended by Emile Bovey on this case, so they're not even on this case anymore. I mean, it is a Pandora's box. I think Bovey sorely miscalculated on this. Bondi, Trump, everyone, I think they sorely miscalculated how this would be. Andrew Weissmann, my friend, it's good to see you. Tell Innes we say hi.
Nice to see you.